Well, good morning. I'd like to call case number 126146, State of Kansas versus Merrill, if council would state their appearances.
Good morning, Your Honor. I'm Jonathan Lawrence, representing Appellant Beth Merrill, and just want to take a second and thank everybody for accommodating me and having the argument today.
And just for those who may be watching, this was originally scheduled last week at Johnson County Community College, but we continued it today, and certainly counsel for the state you should thank as well. We appreciate he did not object. If he would have objected, it would have made it a lot more difficult, but we're here now and we're looking forward to the arguments.
Thank you.
Good morning, Your Honor. May it please the court. The state of Kansas appears by Jacob Gonteski.
Mr. Lawrence, do you wish to reserve any time for rebuttal?
May I split my time 10 and 5, Your Honor?
You may do so.
Thank you.
And let me get my stopwatch on my phone. You may begin.
Thank you. May it please the court. There's a significant risk if the district court's handling of the border issue in this case is affirmed that it can lead to problems in other cases. The district court made its decision on a credibility finding, exalting one opinion of Mr. Wagner, the guy who's in control of maps for Johnson County, over an earlier version of a map that he had. And the difference between the maps is rather drastic. Just setting the timeline, in 2011, there was a survey done, and in 2020, Mr. Wagner created a map which is States Exhibit 28, and that was in 2020. Yet in 2022, a few months prior to trial, Mr. Wagner created a second map, and that was the official map on the website for a little while. The first map had the state line, the border between Kansas and Missouri, run through the left southbound lane on State Line Road. But as Mr. Wagner admitted, just a few months prior to trial, he posted a map to the official website of Ames of Johnson County showing all 5 lanes of State Line Road in Missouri with the Kansas border on the western sidewalk. So if you're heading south on State Line Road, the border is to your right. The entire State Line Road, all 5 lanes of traffic, are in Missouri. So it's rather odd. If the survey on which the district court and Mr. Wagner relied in 2011 was accurate, then why did Mr. Wagner in 2022, a few months before trial, discard that survey and put out this other map? So we have,
before we get there, to answer that question, or whether we should even answer that question, let's go back to the law a little bit. So if I understand it correctly, everybody's in agreement that venue is a question of fact. Is that accurate?
No, Your Honor, I don't agree with that.
You don't agree that venue is a question of fact?
The case law I read said venue is inextricably linked with jurisdiction, and 21.
Well, we're going to get there. It seems to me the cases would say that venue is a question of fact and that jurisdiction is a question of law. But if I'm wrong, I'm wrong on that. But I'm glad you went to the second point, because that's where I wanted to go with this. Is we're really talking here about territorial jurisdiction, are we not?
Yes, sir.
And though in those cases it is linked, venue is linked with territorial jurisdiction. Because if we don't know where the alleged crime occurred, for example, if it occurred on Holmes Road, it wouldn't be a problem. We'd know it's in Missouri. If it occurred on Quivira, it wouldn't be a problem. We would know it occurred in Kansas. But here we're talking about territorial jurisdiction. So we're talking first about venue, which is the locale. And first we need to determine what the locale is, and then we get into the issue about where the state line is. Is that pretty accurate?
Judge, if I might slightly disagree,
Okay.
We know where the accident happened. We know that it happened in the left center lane of State Line Road. We know exactly the site of the accident.
Right, but we know that. Why do we know that? We know that because evidence was introduced to show that, correct?
Correct.
Okay. And so we know that. And if we rely on Exhibit 28, I believe it is, then it would have been at least partially in Kansas, correct?
I believe the car would have straddled the precise line. Yes.
Okay, right. But I think there was an exhibit, I can't remember now, a different exhibit that you've talked about that would have shown that locale, that venue would have been in Missouri.
So here's the problem in the record that hasn't come up yet in the briefing.
Okay.
Exhibit A, which you do not have, was offered, I believe, at page 232 of the transcript, and it was discussed. Now, Mr. Wagner testified fully describing what Exhibit A showed. There was an objection by the state. Ultimately, the court reporter doesn't show, and the transcript doesn't show, that the district court ever admitted Exhibit A. The testimony was in, but Exhibit A itself was not. Then there's Exhibits B, C, and D.
So what do you say? Let's talk about that a second. If it's not in the record, we as an intermediate court of appeals, the court of record, how can we consider that?
Well, I'm not asking you to consider
Okay.
Exhibit A. I'm asking you to consider his testimony, his admission on page 230 of the transcript that prior to trial, just a couple of months prior to trial, after Exhibit 28 is created, he replaces Exhibit 28 with a different map that has all 5 lanes of state line road in Missouri. He says it. So the district court says, in its findings says, and I'm paraphrasing, I find Exhibit 28 to be the best representation of where the border is. And so what the district court did was it made a factual determination on a border. And the danger of that is this. In another case, in a county south of Johnson County, or it can be one of the counties bordering Colorado or any of the other states, but let's just focus on the eastern half of the state. Either another judge in Johnson County, a judge in Wyandotte County, or a judge in any of the counties south of Johnson County can make a different determination factually if this is affirmed on the facts, and we can have a differing border for differing litigants. And I'm not trying to...
Isn't that, though, what the statute tells the district court to do? I'm looking at KSA 21-5106, subsection G. Jurisdiction is a question of law to be determined by the court by the preponderance of the evidence. And it seems to me what you just articulated to the court is that although you don't like the conclusion reached, that's exactly what the district court did, was decided on the preponderance of the evidence presented that Kansas did have jurisdiction.
I would submit 2 things. First, a border should be different. A border is something of national significance, right? A border is established between 2 states by treaty approved by Congress. That's Virginia versus Tennessee back in the 1800s. And that procedure has never been changed. A border is different than some of the venue cases that we have in our Kansas jurisprudence. The border has to be fixed. The border cannot be subject to litigation, disputes, and fact-finding.
Although that happens all the time. States dispute borders. As a matter of fact, in Kansas, there's a statute that specifically was done after was it the 1951 flood, the famous flood, and they went in and they did a survey. And Kansas and Missouri decided where, because the river had shifted. And so they did have to do just that. They had to go in, have a surveyor determine where it's at. There's a Kansas statute and a Missouri statute now that incorporates that, codifies that. But isn't that really what was done here? Is that you had a survey and the court decided by a preponderance of the evidence that survey showed it was at least partly in Kansas?
I agree with what your characterization is of what the district court did. I think the error is it leaves it open to different witnesses at different times with different judges. And that's the problem.
And that's a problem with the statute, perhaps.
Well, the statute...
Subsection G, because it talks about preponderance of the evidence. It's a little strange statute where it starts, this is a question of law, and then it goes on, it says to be decided on the preponderance of the evidence.
Well, the secondary problem with that statute is jurisdiction in these cases is an element. It has to be proven beyond a reasonable doubt. It's in the jury instruction. So we have an unconstitutional burden of proof, if we allow that element, venue/jurisdiction, to be decided by a preponderance, the legislature cannot lower the burden of proof in a criminal case. And I've cited several U.S. Supreme Court cases to that effect in my brief. But going back to...
Well, that's talking about elements of the crime. And I do recognize some states use preponderance of the evidence, some use beyond a reasonable doubt for jurisdiction. There's also a presumption of jurisdiction when the state puts it in the complaint. So, you know, it seems like we, at least in the district court, were bound by the statute.
I believe that this court has the power, if it recognizes that a statute has an unconstitutional burden of proof. I don't believe you're bound by that. I believe that you have the authority to correct it or send the case up to the Supreme Court.
Well, I don't know that we know that, and I don't know that these briefs tell us that this is unconstitutional. I did research this on myself, and there are some states that use beyond a reasonable doubt for territorial jurisdiction. Others use preponderance of the evidence, and they've been doing that for the history of the United States.
Well, I'll be guided by what the court does here. I mean,
well, you're about at your 10 minutes. But while we are at it, do you want to discuss any of the other issues just briefly, so you've at least got them out there before there's a response by the state?
I don't know how much time I have. I guess I'll just jump to just one comment briefly on the constitutionality of the statute that recategorized Ms. Merrill's two diversions. They were 2006, 2013. At the time of her diversions, those diversions would have been scored as misdemeanors under the previous version of 6811. I believe it's subsection C. It just seems to me that unlike other cases that allow for enhancements based on priors, this is the only statute of which I'm aware that post 2015, after her diversions are done, and they're not supposed to be convictions because she completed her contract, then the legislature comes in and says, oh, by the way, Ms. Merrill, we're upping them to felonies. To me, it's a notice argument. That's all I wanted to bring.
And just to refresh my recollection, because my fellow judges, because we've probably focused more on your first issue, what difference would it have made on her sentence?
I believe it would have lowered it by 25 months.
Okay.
I mean, and not to be presumptuous, because on a resentencing, there's still the issue of what concurrent versus consecutive, things of that nature. But the district court did say 57 and 32 running concurrently. I think it would lower it down where 32 might be the high end. And I might be off by a month or two.
So it could, and I wasn't trying to hold you to the specifics, but just the fact that it could have a substantial impact.
Sure. And I did put the correct numbers in my brief. I just...
Okay. And you're at 12 minutes, but
I'm so sorry.
I won't count this against you. Judge Gardner or Judge Isherwood, do you have any questions you'd like to ask?
I had a quick question. I'm sorry. Go ahead, Judge.
No, I just said I don't have any. Thanks.
Mr. Lawrence, on that last issue, was that preserved? The sentencing issue?
Believe it was. I'm not. Are you talking about whether there was an actual objection made at sentencing after the sentence was announced?
Whether this constitutional question was litigated before the district court.
If I can have 1 second, I think I can point you to exactly where.
Sure, go ahead.
Yes, defense counsel filed a motion challenging the constitutionality. It's in volume 18, pages 27 to 32.
But did you get a ruling on that motion?
You know, I don't believe that the judge made a ruling. I figured that perhaps the way to look at it is by imposing the sentence that the judge did and scoring them as felonies. It wasn't overt, but it's implied by the way the sentence was imposed. Does that make sense?
It does make sense.
Any other questions from the panel? Okay, if not, I'll save some time for you for rebuttal, but we'll go ahead and hear the state's argument.
Thank you.
Thank you, Your Honor. May it please the court. Beth Merrill received a fair trial after years and years of protracted litigation in this case. At trial, the state proved beyond a reasonable doubt all the necessary elements of the offense, including that Beth Merrill drove her car in Johnson County, Kansas, eastbound toward State Line Road, while her blood alcohol level was somewhere around 0.317, almost 4 times the legal limit. While she proceeded eastbound on 124th Street, she then turned southbound on State Line Road. And when she did so, she struck the back end of a car where she severely injured the 2 occupants of that other car. That's what brought about the charges in this case. And when the state presented this case to the court, the state established beyond a reasonable doubt all the elements of the offense, including the fact that this offense occurred here in Johnson County, Kansas. And the state did so by presenting testimony of several witnesses, including police officers from Leawood, Kansas, who testified about their knowledge of the state line, their knowledge of their city boundaries, how they've been trained on those boundaries, how they are drilled and quizzed on them when they become police officers, including the maps that they utilize, the paper maps and the digital maps that they utilize in their patrol cars. They testified about the fact that the left southbound lane of State Line Road is in Leawood, Johnson County, Kansas, to the best of their knowledge. And that's what they've always been trained on. And that's how they exercise their police powers, is knowing that the southbound lanes are Kansas, the northbound lanes are Missouri. But beyond that testimony of police officers that was admitted, the state introduced the testimony of a county mapping supervisor. And that was the subject of much of Mr. Lauren's argument just before mine, in which he argued that that testimony was ambiguous or otherwise conflicting. What I would offer to the court is a thorough reading of Mr. Wagner's testimony demonstrates that while Mr. Wagner did outline how various maps on the county website will show that county line in slightly different locations along State Line Road, he explained why those maps demonstrate discrepancies. And when he explained that, he spoke about how photography is taken, satellite images and oblique photography are taken of these different locations. And when you take different data sets, whether it's photography or different types of maps, and then overlay them on the county's mapping software with boundary lines and things of that effect, there can be slight discrepancies with how they are displayed. That doesn't mean the actual boundary is moving. What it means is how it is displayed on the software can have discrepancies. But within Mr. Wagner's testimony, when he discussed State's Exhibit 28, which was admitted into evidence, and as the state outlines in its brief, was a business record of the county mapping department, Mr. Wagner explained that that represents the best location of the boundary line, the most accurate representation of the state line between Kansas and Missouri. And that map, Exhibit 28, demonstrates that red line to be essentially in the middle of the left southbound lane of State Line Road at the location where this crash occurred. That demonstrates that Johnson County was both the proper venue of the case, and it also had jurisdiction over the case. And to Judge Bruns's point earlier, yes, venue is a question of fact, while jurisdiction is a question of law. And the trial court in this case explicitly stated as much when the court made its findings when it arrived at its verdict. This was not a jury trial, it was a bench trial. So the court explained at length how it arrived at its conclusions, both its fact findings and its conclusions of law. And for the reasons the state outlined both at the trial court and here in the appellate court in our brief, there are several provisions within state law that vest jurisdiction over this case in Johnson County. Both the fact that at least some of the elements occurred in Johnson County, as the state already outlined. But even if it occurred so close to the state line that it cannot be ascertained definitively which county the crash occurred in, the jurisdiction is still proper in Johnson County by statute if it cannot be determined where it occurred. My argument is not that it cannot be determined, but that's as a fallback in the event that this court finds the maps to create too much discrepancy. The state still maintains that the maps establish this crash definitively occurred in Kansas beyond a reasonable doubt. But in the event that this court finds it to be so close to the state line that it cannot be ascertained, by statute, jurisdiction is still proper here in Johnson County, Kansas. Another provision of the statute allows that crimes committed in a vehicle, can be prosecuted in any of the counties in which that vehicle goes through or over if it were an airplane. And in this case, it's essentially undisputed that Beth Merrill drove her car eastbound on 124th Street in an area to the west of State Line Road that is definitively in Johnson County. I don't believe anyone disputes the fact that the portion of 124th Street on which Merrill drove is within Johnson County, Kansas. She
But
then,
counsel,
yes.
that might give jurisdiction for a DUI, but how would it also for the aggravated battery?
It also would for the aggravated battery because by statute, as long as one element of a multi-element offense occurs within this county, then even if other elements of the offense occur in other counties, jurisdiction is then proper in either county. So by driving in Kansas while she was over the legal limit, just within seconds of this crash, the state established that element, one of the elements of the aggravated battery for which she was convicted. And I would note, she wasn't simply convicted of aggravated battery, the bare aggravated battery that would be charged if in a bar fight, for instance. That's not the form of aggravated battery that Ms. Merrill was convicted of. She was convicted of aggravated battery while DUI. And under that statute that she was convicted, the state had to establish that she inflicted great bodily harm on others and so on, but that she did it while she was driving under the influence. And that element of driving under the influence clearly, indisputably happened in Johnson County, Kansas, when she was eastbound on 124th, either seconds or a minute before she barreled into the back of Ms. Roby's car and inflicted these injuries. So even under that reading of the statute, jurisdiction maintains in Johnson County, Kansas is still proper.
And counsel, from reading the cases, it looks like Kansas would recognize concurrent jurisdiction if the crime did occur. I mean, it doesn't seem like it'd be that uncommon. You would know more than I would, being in Johnson County District Attorney's Office, but it seems like it wouldn't be all that uncommon that somebody might commit a crime in both Kansas and Missouri when they're driving on state line. And I believe Kansas would recognize concurrent jurisdiction, and the only limitation would be you can't be convicted in both states, but you could certainly, both states could have jurisdiction. Is that accurate?
That's precisely how I read the law as well, Judge. I believe concurrent jurisdiction is proper.
So where do facts come into play on this? Because I'm looking at the statute, just again, I know you both know it, but KSA 21-5106G, which starts out jurisdiction is a question of law to be determined by the court, which is what the district court did. But then it goes on and says by the preponderance of the evidence. And you heard counsel's argument. There's two things. First of all, whether or not this met preponderance of the evidence, but then second of all, is that an inappropriate standard for determining territorial jurisdiction?
2 points to that, Judge. I would state, in this case, when you read the district court's verdict, I believe as though, although the district court did not use the words beyond a reasonable doubt when it was discussing jurisdiction, I believe the findings that the district court made rose to that level. If you read the verdict and how the court explained how it arrived at its conclusions, I believe it explained, it essentially satisfied a higher burden. The court did not discuss the preponderance of the evidence threshold that is in 5106. And so I don't believe as though, even if that burden is perceived as too low, I don't believe as though it created an infirmity in this verdict, given the nature of the verdict that was explained by the district court judge. But before we even get there and delve into that, I would also put to this court that constitutional challenge to the statute, arguing that it sets too low of a burden on the state is essentially a constitutional challenge. That is not a claim that was ever raised below. And a constitutional challenge to a statute like that should not be addressed for the first time on appeal when the appellant did not give the district court an opportunity to litigate that aspect of this statute. Jurisdiction was certainly challenged in this case, but the claim that was made in the appellant's brief, in Ms. Merrill's brief, is almost as an aside. Within one page of the brief, there's essentially a parenthetical that states, And perhaps 5106 is unconstitutional as setting too low of a burden on the state, given that it's an element of the offense. So it's almost an aside that this constitutional challenge is posited within the brief, but that is not one that was raised below. And frankly, it's not even one that's very developed within the brief here at this level. So I don't believe as though this court needs to address the constitutionality of that statute. But even if it does, I believe the state's evidence in this case demonstrates beyond a reasonable doubt each of the elements had been established by the state. And Mr. Wagner's testimony about State's Exhibit number 28 is worth reading and worth reviewing in full if you are looking to examine the discrepancies between these maps, because it is Mr. Wagner's testimony where he explains why some of the maps have discrepancies in a very fine resolution, very fine level of detail. The county mapping software is fairly robust. It's a product that's put out for not just the general public to utilize, but for all kinds of parties to utilize for all kinds of different things. Real estate agents and so on use that mapping software frequently. But the mapping software is not and in and of itself, as Mr. Wagner testified, they utilize surveying results. And the red line that is on State's Exhibit number 28 was placed on that map as a result of a survey that was done for the county in 2011 or 2012. And it was that survey that was conducted that Mr. Wagner testified about as being the best representative of where the boundary line is. And that's the testimony the state relied upon in this case. That's the best evidence in this case of where the boundary line is. And that's why jurisdiction was proper, as was venue. And the district court did not err in how it discussed venue as a question of fact versus jurisdiction as a question of law. I'd like to also touch on the ex post facto argument about the sentencing provision. This court does exercise unlimited review of that kind of question. And I agree with Mr. Lawrence that that question, that constitutionality question was preserved below. The law that was enacted in June of 2015 which was before the offenses in this case, well before the offense in this case, it sought to enhance the penalties of individuals that would be convicted of aggravated battery while DUI. And in order to enhance the sentences under that statute, what the legislature chose to do was say, if going forward, after today, if you are convicted of aggravated battery while DUI, and you happen to have DUI priors in your past, those DUI priors are going to essentially work to aggravate your sentence even more than they used to. This is not an ex post facto violation by recharacterizing the old convictions on Ms. Merrill's record, because an ex post facto violation would only come into play if her sentences were altered on those former offenses, if she had not been put on notice as to what sentence she would receive in those old cases, or if the state sought to enhance the penalty she already served on those prior offenses. By recharacterizing or redescribing Ms. Merrill's prior DUIs as felonies for purposes of the sentencing guidelines grid, all it did was move her along the grid. It didn't actually change her sentence in her old cases. It worked to elevate the sentence in this case. And the legislature is free to do that. The legislature is the body that has the authority to establish penalties in criminal cases. And by changing this statute in 2015, it sought to elevate the sentence that would be imposed if you committed an aggravated battery while DUI and you had prior offenses. It would be no different if instead of recharacterizing her prior offenses as felonies rather than misdemeanors, they could have just said, instead of calling it a level 5, we'll call it a level 4 or a level 3. The net result is they were seeking to enhance the sentence, to elevate the sentence. And they chose to do it by characterizing the prior offenses differently than they had been when they were sentenced. But because it did not change the penalty in those prior offenses, it is not an ex post facto violation. Ms. Merrill was on full notice. Yes.
And that was what my question was about notice. The statute was changed in 2015. This accident occurred in 2016.
Correct. And so well before she committed this offense, She was put on notice by the Kansas legislature when they published the new statutes in 2015. They put everyone on notice in 2015 by stating, if you have prior offenses for DUI, then going forward, if you commit an aggravated battery while DUI, you are going to be subject to these enhanced penalties. It's not an ex post facto violation because it did not add any penalty to Ms. Merrill at the time the statute was enacted. It only said, if you recommit, if you reoffend, then you will face an enhanced penalty. And the United States Supreme Court has classified these types of statutes where legislatures seek to further penalize conduct that is repeated and that goes on and on. That type of a statute is not an ex post facto violation because you're simply seeking to enhance a penalty for a new offense as a result of prior conduct. When the legislature changes severity levels of different crimes, they move people into different boxes along the grid, and where they lie on the grid will necessarily be a result of their prior convictions. But because those prior conviction penalties were not changed, it's no ex post facto violation here when she faced her penalty for this 2016 offense.
Just on the procedural issue, I want to make sure that I understand that you believe that it was appropriately raised before the district court, and even though there may have not been a ruling on that, that appropriately preserved it for us to decide on the merits.
I believe so, Judge.
Okay,
I believe so. I did not, unlike some of the objections to the border testimony, the preservation claims that I made in issue number 2, in issue number 4 about this constitutionality of this enhancement provision, I did not argue that it was unpreserved.
Okay, thank you.
Now, whether or not this
You're a little bit over your time, but we've asked you some questions, but if you can start to wrap up.
Understood. The United States Supreme Court said in Nichols in 1994 that enhancement statutes are common and they do not enhance the penalty for the earlier conviction, only for a subsequent one. And by that nature, they are not ex post facto violations. I would welcome any of the court's questions, but understanding my time is up, I would ask that this court affirm the district court's verdict and sentences in this case.
Judge Gardner or Judge Isherwood, do you have any other questions?
No.
Thank you.
Thank you. Mr. Lawrence, rebuttal.
Thank you. Turning back for just one moment to the state line question, the border. Mr. Wagner on page 230 made clear that in the months prior to trial, which was 2 years after Exhibit 28 was created, he put out another map that had all 5 lanes of traffic in Missouri. That means that not a single part of this offense, the evidence of which was all collected on State Line Road, would have been collected in Kansas. I'd like to just briefly address the notice argument. First of all, distinguishing this case from Nichols, Ms. Merrill's 2006 and 2013 diversions were not convictions. The agreement was it won't be prosecuted if you complete this little contract. So what she was not told in 2006 or 2013 is when you sign on the dotted line, you do your classes and you pay your money, someday we're going to claim that those are prior felonies. She might not have entered those diversion contracts. She might have gone to trial if she knew that the state of Kansas years later was going to call her diversion contracts convictions and not just misdemeanors, because originally at the time she signed the contracts, they were misdemeanors, but now we're going to convert them to felonies. Which
Did she know, was she given notice though that at whether felonies or not, I understand your issue there, but was she given notice that those diversions could potentially count as DUIs and if subsequent DUI cases?
I believe that the statute in effect at 2013 did have that. I'm not sure about 2006 because I think that the statute came into effect in 2011, but certainly the 2013 one, she was on notice that they would be converted to misdemeanor convictions, but not felonies. And that's my problem with this is the notice doesn't go to what happened in 2016. The notice goes to what happens at the time she signs the diversion agreements and carries out her part of that contract. So if I just have a couple of seconds, not to go all the way back to the very beginning, but I am very profoundly thankful to everybody for handling this today. That last Tuesday is the worst experience you can imagine. It really is surreal to think, how could I have missed this? I wrote this down, and so I'm very thankful to everybody for giving me this chance today. So with that, I finished.
We appreciate that, and I'm sure that it's been a valuable learning experience to you. And again, I appreciate both the council's cooperation in this matter as well as the panels. So with that, we will adjourn, and we'll take this matter under advisement. And as you know, we try to get our opinions out within 60 days of the argument. Assuming we have no computer glitches or security incidents between now and then, that will be the goal. But bear with us that it could be just a little longer than that.
Thank you.